We're going to continue our discussion of originality, the second component to determine whether or not a work is subject to copyright protection. We covered works of authorship. We're on the second element of originality. And I'm going to start with a case, and we're going to pick up with that second the second element of that test from the Feist case. Minimal level of creativity. We're going to expand on that a little bit more. But I'm going to start with a case, Magic Marketing versus Mailing Services of Pittsburgh. It's a federal court case from 1986, and the issue involved was the plaintiff had an envelope, and on the envelope was various markings that they would print on the envelope. Things like prior message, contents require immediate attention, and words like telegram, priority message, gift check were printed on these envelopes. They were pre-printed envelopes, and the defendant started doing that on their envelopes. So Magic Marketing said, hey, you can't do that. It's copyright infringement. So the facts were there was an envelope that was copied by a printing company. It was a lawsuit for copyright infringement, which was brought because the claim was because the design and symbols and overall look was in quotations, used on the envelopes, was copied. And the issue that the court had to determine was whether the markings on the outside of an envelope are copyrightable. In particular, priority message, contents require immediate attention, was on the back strip of the envelope. There was no pictures, there was no designs that were printed on it or on the face of the envelopes, just a solid black strip. And the court said, what do you think the court said? You might be reading the slide in front of us, and I'll get there in a second, but this court said instructions and wording that tells of contents of envelope is not copyrightable. So envelopes describing their contents with phrases such as telegram, gift check, priority message, these things, or other language that notes the contents of an envelope that require attention are generic in nature, and they lack the minimal degree of creativity necessary for copyright protection. So the court said no originality for words that are printed on the outside of an envelope. And the Copyright Office, I also note that the court noted the language from the statute that says the following works are not subject to copyright: words, short phrases, names, titles, slogans, familiar symbols like a square or a triangle or a circle, lettering or coloring, or a list of ingredients are not original. So just reaffirming there has to be some level of creativity. How much? Minimal. And the Copyright Office this is a code regulation. This is not from the Copyright Act. The code regulation, the Copyright Office actually set certain standards of works that are deemed non-original. So what that means is if what the work is one of these, it's going to be deemed already non-original. Calendars, standard calendars, height and weight charts, tape measurements and rulers, schedules of sporting events, and lists or tables taken from public documents or other common sources. And also they know words, short phrases, names, titles, and slogans. And to note from the case that I just read and from the statute, merely adding commonplace elements fails to establish minimal creativity. Remember the last case, the Feist case, alphabetical, naming people in alphabetical order is not a minimal degree of originality. So let's expand on minimal level of creativity. And I show you this photo. And the question is, can you use a device to create a work? The issue in this case was whether an author can use a mechanical process in creating a work. So what this is a United States Supreme Court case, and it's a very old case. Let me give you the background. It's from, ready, 1884. Yes, we had copyrights back then. We are working with different statutes. But what is happening here is that the photographer, this is Burrow-Giles with a lithograph company versus Sarony. And what we have here is the photographer, who is Sarony, took a photograph of Oscar Wilde, who was a famous actor in that day, a public figure, and took his picture. All right, had a camera, fancy old school film type camera, or however they made photographs back in 1884, and took his picture. And the lithographic company wanted to use that picture, and they did. They used it. And she said, wait, you can't use that without my permission. It's copyright infringement. And they argued was, no, you didn't produce anything. You just merely reproduced the exact feature of a natural object. This person, Oscar Wilde, you didn't do anything creative. You just merely reproduced that human being. So the question turned on whether or not that was original. So think about it. What you know now about photography. Something good must have came out of this case. This is still this is 1884. The new laws for copyright certainly protects photography itself under one of the categories. But we still have a lot to do with photography. We're going to talk about photography because Photoshop is a big deal now. Photos on social media is a big deal now. And this is our beginning case of it. So the court said, while you did take a picture of a human being, what did the author do? And they did it with a camera, mechanical device. Is there human creativity involved with that? If you use a device? So the court found or said that there's a wide variety of things that are subject to copyright, not just books. And while Congress can authorize copyright in all forms of writing, by which the ideas of the mind of the author are given visible expression, so far as they are represented of original intellectual concepts of the author. So what did we have here? We had mental conceptions. What did our photographer do? Any photographers out there? What would you do? You're going to take somebody's picture. You're going to probably pose them. You're going to choose your lighting. You might pick out their wardrobe. So all of that mental conception made the photograph the author's original work of art, even though the photograph was mechanically produced and it was of something, an object that already existed. The same argument could be made as taking a picture of a building. You're traveling to a city that you've never been before and you're taking pictures, and you take a picture of, a sculpture. Do you have a copyright in sculpture? No. Do you have the right to take a picture of it? You can't take a picture of my sculpture. Because if it's my sculpture, can I claim copyright protection? And no, I could take a picture of that. You might want to get permission to take a picture if your plan is to sell it off. But if you add to it, we'll see. We'll see this in a later discussion, and maybe I shouldn't go here to muddy the waters on originality. But if you change it in some fashion, that original component, you add a little bit of, it doesn't have to be novel, some minimal degree of creativity, becomes yours. we'll visit the difference between that concept and derivative a little later. We're fleshing out this idea of originality. So, photographs you take based on your mental conception is going to give our photographer a copyright in their work, because there is some minimal degree of creativity, even if they're using a mechanical device to capture that photograph. So my next question is, that might not, oh yes, yeah, I did. My next question, jumping the gun a little bit. My next question is, now, can I go and get a look-alike and set up this scene and take a photo? I like this photo and I want to recapture it. Can I get a look-alike? And that issue was visited in the court system in New York, federal court in New York in 2008. Oh, by the way, this is, apologizing and flip the switch here. This is that case that I was just talking about with that was the photograph we were looking at, and the issue is whether an author can use a mechanical process in creating work. It's the human mental process in creating the photo. The only elements that created it are protected, like the posing talent, the lighting, and how the one goes about taking the picture using their mental conceptions. Again, only the elements created. So we go back to, can I take a picture of the Empire State Building when I'm in New York City? The answer would be yes. All right. This is where I was headed with my next question. Now, can I go out and get a look-alike and set up the scene and take a photo? And this is what happened in this 2008 case. Mr. Mannion sues Coors Brewing Company and an advertising agency that Coors Brewing hired to make that billboard that you see there. Now, Mannion is the photographer, and he took a photograph, the one that you see on the left, if you're facing the screen, the left-hand side, of Boston Celtics NBA forward Kevin Garnett. And he took that picture, and that picture was in Slam magazine. Yep, basketball magazine called Slam. That's the picture. That's the pose. And Coors hired an ad agency to design a billboard. The ad agency actually saw and liked that photograph from the Slam magazine. They got somewhat of limited permission to use that photo from Mannion as merely as a prop, meaning they wanted the permission they got was, hey, we want to pitch this billboard that you see to Coors in some fashion. They were mocking it up, so to speak, to show Coors, and they got permission to use the exact photo, the one that was used in the magazine from Mannion. Okay? Then what happened was the ad agency was speaking with and trying to find a photographer to actually do the billboard or create the billboard after they got the go light from Coors Light. And Mannion was one of the people that they sought out but ultimately didn't end up hiring. So what they did, they certainly didn't license the photo to use in the billboard. What they did was, with their new photographer, they did a repose. They got a look-alike, they dressed him up, set him up in that pose, and there's the ultimate billboard. And Mannion sued for copyright infringement. Now, it's not the same exact picture. I mean, crop it out and crop it and use the same picture in the ad. Is this copyright infringement? Where they are mocking, basically. I want to do a look-alike. I want to recreate that picture and use it in my ad. This case went all the way to a jury. What do you think happened? This case is in the book. You can read all the details. I just like to summarize it, but you can certainly flesh it all out and read ahead if you're very much into photography. Like I said, we're going to explore a lot of photography as we go along, as a result of, we all taking pictures on our phones, and they're all going up on social media, and other social media sites are snatching them off. And there's actually artists who take other people's pictures that they take on Instagram and modifying them. So pictures, photographs, it's a big deal in the copyright world. So what happened? Jury ruled in favor of the photographer, said this was copyright infringement. And a jury doesn't have to say why or how they got there. But in this particular instance, on those facts that I just told you, this constituted infringement. Maybe it turned on the fact that they were already familiar with this photograph and were using this photograph, and instead of doing the right thing and licensing it out and pay for it, they said, well, we're going to do this other thing. We're going to copy it. Right? That's what they did. They copied it. We're not actually copying that. We're using a lookalike. Anyhow, so copyright infringement on a photographer when you use another person's photo and create an exact copy. This is kind of reminds me of that. The Three Stooges case. Remember, certainly they're infringing on the likeness, and we're not talking about Kevin Garnett coming in and saying, hey, you use my likeness to sell Coors. That would be a whole nother issue. But it's very similar to that Three Stooges case where the person literally copied what they saw. They may have drawn it out, and they have really nice penmanship and drawing skills, but they made an exact copy. It wasn't any sort of artistic expression. All right, let's move on to sweat of the brow, not sufficient. What do I mean by that? Well, we know that the amount of creativity to meet the originality requirement is not great. We saw, we kind of did see that under the Feist standard, that there is no substitute. There's no substitute for creativity. So the author cannot win protection by showing, this is what I mean by sweat of the brow. Sorry, I'm getting a little ahead of myself. Sweat of the brow. So we need some sort of creativity, but the author cannot win protection by showing that he invested considerable resources, time, and money, i.e. sweat of the brow. You still need to have creativity. And a case that I have that shows that, and I kind of alluded to it last lecture with the biologist who did all that research on the elephant, gathering, information about the elephant, weights and so forth. Like those are facts, and they're not copyrightable. Spending all this time compiling all the people who live in a city and then listing their names in alphabetical order with their telephone number may be a lot of work, but it's not original. The case of Amsterdam versus Triangle Publication, I think this one is in the book. This is out of federal court in Pennsylvania. Yep, high federal court out of Pennsylvania. It's from 1951, but it still proves the point I want to make here. So the plaintiff publishes maps, and he published and copyrighted a map, the one in question, and the defendant is a publisher of the Philadelphia newspaper, the Philadelphia Inquirer. And in its paper, and so our plaintiff, who's Amsterdam, sues Triangle Publication, who's the owner of the Inquirer. And in its paper, what it did was it has a section that's called, quote unquote, Everybody's Weekly. And the defendant published a map of Delaware County in connection with a historical article relating to that county. And the plaintiff claimed that they used his map. You copied my map. It's infringement. And the newspaper argued that, yeah, we copied it, but your copyright is invalid because you aren't entitled to a copyright because the map's not original. It's not an original work. So the question was, did the plaintiff do sufficient original work to be entitled to protection, whether or not there's some minimal degree of creativity? What he did in creating his map was he studied every map in Delaware County that he found. He did not do surveys. He did not investigate roads or county lines or townships or the creeks. All this information was obtained from maps that he had or obtained from the towns or the municipalities or the highway department. He distributed, he obtained some names on small roads, not on his own accord, but from real estate agents. But all the information on his map came from maps already in existence. But none of this info had ever been published previously on any one map. So basically he took from all these resources and put it into one, all these resources that are in the public domain, and put it all into one map. And he spent a considerable amount of time and effort to assemble it. But the question was it original? And the court said no. You did very little original work. All you did was collect all these facts from other places and put it onto one map. So the court said no. So the Philadelphia Inquirer did not infringe. So to answer the question that's on the screen, what if the author invests considerable amounts of time, money, and resources into a work, gathering thousands of names and numbers for a telephone directory, for instance? Is that enough to get a copyright? No, it's not. What if, well, think about this. If copyright serves as an incentive to produce works, could it be argued there should be copyright protection for these kinds of things? Right? If you want incentive to produce works, if so, what's the incentive? Right? Why would people go out and collect valuable information? It's just the same as giving copyrights to the, giving the incentive to the authors in specific categories, right? That took a lot of time to put that together. Didn't you want to be able to use it? But unfortunately, that's not the case. You need some degree of creativity. All right. How about this, though? Could there be protection some other way? Could there be protection for some other way? Maybe it's not copyright, maybe it's something else. Contracts. There could be a contract to use something for certain conditions. If somebody went to use this particular map, maybe having an agreement. It's hard to keep it a trade secret. It's not really covered under trademark or patent. But maybe they can get protection some other way, but it's not under copyright, which is what we are talking about. All right, next. Let's talk about new works. These are factual works, compilations, and derivatives. These things may incorporate non-original elements. That's what we're going to expand on now, as soon as I find my case. All right, according to the Copyright Act, 17 U.S.C. 103A on the screen, subject matter of copyright does include compilations and derivative works, and B, copyrights extended to these works extend only to the material contribution of the author. This does not give the author a copyright in the pre-existing work. two very important concepts, because compilations, we talked about, it's, compiling works that are already together, a whole bunch of, nature poems all in one compilation. You don't own the copyright in the poem, you own the copyright in the compilation. Same thing with the derivative work. I don't know who created which movie production company created the Harry Potter movies, but we know J.K. Rowling owns the copyright in Harry Potter. She contracts with movie company to make all those movies. That's a derivative work, and the movie company owns the movies. She might get some sort of payout. She might get some sort of, I get to give my opinion on what happens in the movie, but she doesn't own the movie. So these works must be original too, in their own way, but not a complete, but it doesn't have to be completely original or even mainly original, as I just explained. Every novel, we know, we all read novels, if you're a big book reader, they include words, and they include phrases, and they include events and personal characters and other elements that the author has learned from others. I mean, they all stem from something else. It's not, every story has, the three acts to it. Every painting, there's abstracts of painting. They have elements that are copied from others. How many paintings of sunsets, right? Everyone's got their different take, but there's, a bluish sky and a yellow or an orange sun, and so there's always elements that are the same, but when they add their own originality to it, it makes it a different copyright, or a copyright in the new work. And our test for this is the originality analysis considers, I don't have a slide on this, so I'm going to say it probably a couple times. Our test, the originality analysis considers how much was copied from others. Okay? I'm going to repeat that because I think I left a word out when I was saying it. When we're doing the originality analysis, you consider not how much was copied from others, but whether the author added anything creative to his or her own to that work. Okay? I'm going to say that again on the test of originality. You don't consider how much was copied, but whether the author added anything creative. Okay? That's our overall thinking about when we're thinking about originality, and we're going to apply the two-part test from the Feist case, because that is our law on the issue of originality. And I want to go through just a couple more points. What is a factual work? And I've dropped this example a few times already in the last slide and this one. What is it? It's basically a factual work serves to present facts. It could be a historic book. It could be a scientific book. How it is presented or expressed is copyrightable. Okay? So if you're writing a book about George Washington, the information in it is factual. That is not copyrightable, but the book itself, how it is presented or expressed, is copyrightable. Okay? You can make a documentary on President Kennedy. The factual information in it is not copyrightable, but the work itself, the documentary, is. Derivative work, what is it? We've talked about it. It's based on a pre-existing work, but reflects creativity element from a second author. And the best example that I love to use is the books to the movies. You can have the books and the characters to little figurines, right? You can expand that to posters, whatever. It could be to books. You can go from a movie to a book. I think Star Wars started as a movie and then went to comics. They made comics, or books of it. I think it was that way. So derivative works. It's a new work established from a pre-existing work. Compilation, we talked about it. It's collection or assembly of pre-existing works or data. The selection, arrangement, or coordination of these elements is what gives it its originality, and compiling it into one source. So just not to confuse a compilation of everybody who lives in the city of Plattsburgh's phone number in an alphabetical list into one book. Technically, you kind of look at that as a compilation, but doesn't have any originality. It's how it's organized and how it's put together that gives it its originality, and ultimately its copyright protection. So my next question is, can a home movie that captures a historical event and ultimately news be subject to copyright protection? And this issue was addressed in federal court in New York in 1968. We're going to come back and revisit this case again when we talk about infringement. But the question I'm posing, and then I'm going to talk about the Time magazine case here. Videos and photos. So, home movie captured a historical event and ultimately news be subject to copyright protection. And this is what we're talking about. This is Kennedy, John Kennedy, when he's assassinated. Now, to tell you a little background about this, what you have seen on the Kennedy assassination, when you've probably seen the video clip, you've probably seen pictures like this in books and magazines and movies and documentaries. There was only one source who caught the incident on video, and that's where every single photograph, the movie comes from, filming of it comes from, is this one source, and I'm going to tell you about. There was a photographer. Actually, he wasn't a photographer. He was just he owned a business, dress manufacturer, Abraham. And he just happened to have a home movie picture camera, which was big in the 1968s to have something like that. And he was in Dallas, and he spent time looking for the best place to film this. The president's going to be in downtown Dallas. I want to film this. And he went around town looking for the best place to set up his camera. And lo and behold, where he did, he had he was on top of a bank building, and he filmed it. He watched it all unfold before him, and he immediately took his camera in to be processed, because that's what you had to do. You had to bring your whole camera in. They had to pull the film out, make it into film. He got 3 copies of the film, and lo and behold, he has the entire event. And of course, he notifies law enforcement. The Secret Service come because they need to investigate what happened. He gives them strict instructions, because the government just can't take your copyrights, by the way. The government doesn't have free reign to use your copyrights without your permission. So he says, sure, you can take one of the films, but I plan on selling this, of course, right? This is big news. So you can make money off of this. So the Secret Service ends up making a deal and buying the copyright for who knows how much money. I think it was, back then it was like $200,000. So he relinquished his right to that. At some point in time after the investigation, there was 3 different films, by the way, that were taken. The films were stripped down into their frames, so that what you're looking at is, a hand-painted, according to the case, they said this was a sketch, but it ultimately ended up being an exact copy of the picture that was used in a book. But at some point in time, Time Magazine ends up with the rights to this video. So Time Magazine owns this rights. However, when they closed the Kennedy investigation, one of the films ended up at the Smithsonian, or it's recorded somewhere in some library that's free. I mean, it's considered public domain, but this particular document is actually labeled the property of whatever Time Magazine's corporate name is, and any use that isn't for teaching or research you need to get permission. So anyway, that's the background, and we're going to revisit this case again. But I think it's important because we all know or have seen this in history class or seen these photos. And when I learned that only one person had ever recorded this, and what we see is what's subject to this case is fascinating. So anyway, this one picture and a couple others gets used in a book about Kennedy, and Time sues. He didn't get permission to use it. And the question becomes whether or not, because the argument was, this is an historic event. This isn't copyrightable. This is the only one that exists. This is public domain. This isn't copyright protected, especially since it's been out and it was used for investigating and so forth. And the court said that, nope, that the recordings of the question was whether a photograph of a street scene showing this historic event is subject to copyright on the basis that it is a historic event or a newsworthy story was the issue. The court said no, it's copyright protected. The infringement by the defendant is a copyright infringement. It was taken by somebody at work of authorship, and it's original in the event that it captured an event. That's what he was intending to do, was to capture this event of the president traveling in his city. Nobody knew what would unfold, but you need permission to use it. And I think this is going to follow, this ruling follows us, like I said, we're going to talk about a lot of photograph cases, and I'm going to just interject here. We're going to talk later on about Instagram, news agencies like Fox taking people's photographs from their Instagram page that captured newsworthy events and using them without permission. This is the same. This is kind of, we're on the heels of that. This is the beginning. So here, the purpose for this discussion is the court is ruling that no, just because somebody captures a historic event or a newsworthy event, it is still, whether it's a photograph or a video and such, it is still original enough to be considered for copyright protection. So we're going to revisit this when we talk about the infringement portion of the case, because there may be another argument that allows Mr. Bernard to use this newsworthy event. But we'll save that for a little later in the semester. But for now, it's original. It doesn't matter if it was historic or newsworthy. So that finishes up our originality discussion. So we did our works of authorship. Before our work can be subject to copyright protection, we need a work of authorship. We need originality. We're going to move on now to fixation.